Okay. All right. No one's remoting today? Okay. Well, welcome everybody to today's commission meeting. It's just a point of reference at just before right after the instruction in the top of the page, we are starting to add in the next two commission meetings that will be coming. So the next one will be June 29th and July 13th. That's for staff as well as for public information. As we begin all these meetings, we like to start with a prayer reading or a thought and a pledge of allegiance. And we like to ask or invite someone from the audience here to volunteer for one or the other. Are there any here that would like to offer the prayer or pledge?
How will we do the pledge?
Good. Thank you. We'll do the prayer first, and then we'll do you, Deputy. Anyone for the prayer? Then we'll bring it up here then. Actually, okay.
Our Heavenly Father, we are so grateful to be able to assemble peaceably here and to be able to go through issues of the day. We're thankful, Father, for this great land that we live in, this great area. We're thankful for the safeties and the protection. We ask that those who are continue to provide those for us will be protected and guided always. We're thankful, Father, for this process. We pray that we can go through it in appropriate ways and keep civility in our mannerism. And we pray in the name of Jesus Christ. Amen.
Amen.
All right.
Deputy, would you let us know who you are?
Sergeant Holden Rockwell, Utah County Sheriff's Office. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you.
Thank you, Deputy. Okay, we have no recognitions or work session items that I'm aware of. So we will go ahead and go directly to our consent agenda. And that means we will go ahead and review the regular agenda items and see which ones that we've already previously reviewed and have no questions on that we can place into consent. And with that, and then discuss the others in the regular agenda. So with that, we'll go with 1 through 10. Are there any items you would like to hold, commissioners, for discussion?
Number 4.
4? Okay. Any other?
Nope.
Okay, 11 through, through the rest of it's 22. I'd like to hold the number 11 to discuss. We kind of compared briefly some notes last evening, but I'd like to talk a little bit more through it, that one.
Nope, I'm good with the rest.
No others from 11 through 22? I think we have
Commissioner, number 20 needs to be
continued on number 20.
Their legal needs to take a look at that. We can continue it maybe till next week.
1 week is enough for you?
A week enough? Yeah.
So June 29th then? Okay, so we'll continue number 20.
Okay.
And we have, I know 26, are there any other items that need to be held for closed session? Robert, any others that come up since we talked?
No,
Okay,
just
so,
number 26 litigation.
so strike 23, 24, and 25 then?
That's my understanding, yes, thank you.
Okay. All right, with that, Alice, would you review what we had just put on to consent?
You bet. Okay, I have us holding agenda item number 4, 11, continuing item number 20, 1 week to June 29th. And as far as closed meetings, we're going to strike items 23, 24, 25, and holding as stated 26.
All right. That's what I have. Any other questions from the commission?
No.
Okay. With that, we'll then go on our regular agenda. Number 4, Commissioner Lee, you wanted to discuss that one?
So on the list that's on there, there are 4 items that I'd like to talk about. The prime time real estate one, Revere Health, Holdaway, and the Besant. So starting first with the prime time real estate, I know that Adam and I have had some conversations on this. My questions on this revolve around first that we wrote off some taxes on this from 2009 to 2017, and then after that, I'm not sure what happened and what's different on there, but it seems to revolve around a virtual office. I'm just not quite sure what's going on with this item.
Paulette Stetzer with the Assessor's Department Office. I reviewed this account this morning, and I have verified with the City of Orem. Currently, they're not aware of a virtual office being located at this location, as well as this business currently is operating without a license. So, with that said,
Okay.
it seems to be that he moves from location to location, but our records show no return mail of any way. So I'm not exactly sure what constituted the abatement from those years prior to, but at this current time, I still show no return mail for this entity. So to the best of our knowledge, all mail has been received.
Okay. If they don't have a business license, do they have one with the state?
I have not verified that.
So I'm just wondering if they're not recognized as a business, how are we taxing them?
Well, the information that comes to our office comes from the city originally. They were originally located in Provo, and they moved from a Provo location to Orem, and we weren't notified of that until February of this year is when we updated that. So, and yes, I do believe they do have a business license with the state.
Okay.
In looking at the notation here, per Dana from the Treasurer's Office, that the business website, there is a email address for this business as well. And at this current time, what we show all mailing going to is the location in Orem, which he states is a virtual office. Now, with that as well, 2022 tax bills have not been sent. I haven't processed any as a mass. So those will not be going out till the first week of July. So he's not been assessed for 2022. It's 21 and back.
Okay. So to kind of recap that, we're not getting into the legality of if they're a business or not, or if they have a business license with the city that they're in. But the reason why we're taxing them is because they do have some sort of articles of a business with the state of Utah, and that's where
Correct.
that's what we go off of. Okay. Okay.
Jeannie Bowen, Treasurer's Office, quickly. So this came to light because I physically went there and served this business. So it is the mail and things are actually being accepted by another business at that location who has, like he kind of has an agreement, and so it is kind of a virtual business, but he still should have filed, absolutely. So, but that is why it's not returned. And how we kind of found out where he was and such, because I served him.
Okay.
Thank you.
Thank you. Well, I'm inclined to just leave that the way it is.
Yeah.
No change to that.
And then the next one that would like to talk about is the Revere Health one. This one here has what appears to be they sent records in on their personal property, and then for some reason they sent records in, they doubled it. So it appears like they sent their records in and then also sent the same records in, so it's twice where they only have. And it's no, I mean, your office only goes off what they send you. I get that.
is
So you just go off of that, but it appears like they double entered it. Would you say that's accurate after looking through the information?
Paula with you, assessor's office. I did review the account after I was notified, and I was not notified of this error until.
And this is not a county error. When you say error, this
No.
would have to be on their side.
Correct.
Yes.
It was information provided to our office for 2020's filing,
Right.
so updated as it was received. And I believe there were no class changes made, so it went specifically off of their filing. And we weren't notified until, let me look at this here. December of 2021 is when I got the call, so it was over a year later, give or take, that we were notified that there was an error on the 2020 filing, and I had advised him what he needed to do, and so this is where we're at this point in time. But following year for 2021, they corrected it, removing the duplicate items,
Yeah. Right.
which again shows in the adjustment as far as their tax bill.
So with this one, commissioners, I'm inclined to tax them on the appropriate basis and just cut that portion in half, if that's correct. If it was a double filing, then half of that should be the correct amount.
Well, what you're seeing here is what they're requesting as a refund, which would have been their duplicate items, because the tax bill for that year was a little more than double that.
Yes.
So,
So what they're
yes.
requesting is the half that we're talking
Correct.
about.
It would be the full request.
So
That is
we would be going with the full request with an understanding that it was
Correct.
basically half of the original.
I think that's reasonable.
Yes.
Okay with
Yeah.
that? Okay.
I'm okay with that.
Good.
Those were the easier ones. The next one is the Holdaway property. I know we've got Robert Filler up here on this one. This one's been going on for some time. I'll make a recommendation on this one, and that is that this one has a lot of complications to it. It's been going on for years and years and years.
Yes.
I would make a recommendation that we talk about this one, gather information, because this is the first time for us as commissioners all together. We've probably had separate conversations, and I know, Amelia, you were the clerk auditor, so you've had different conversations, and so I'd appreciate hearing questions from all of us on this and not taking action on this one, but gathering information on this one so that we can then maybe circle around, because there's a lot to this one.
Right. And there is pending litigation with the state, right?
Right. Right. Is that fair enough?
Yes.
Yeah.
Yes.
You want to start us off?
Yeah, I can start off. Adam Beck, County Attorney's Office. Yeah, so this parcel goes back some time. This parcel was in Greenbelt in the early 2000s, and then it got off of Greenbelt.
So, Adam, I hate to jump in. Are you talking parcel or parcels?
Parcel,
Singular.
I believe just one.
Okay.
And the property has over the last couple decades, the value of the property has decreased. They rolled there was a rollback when it got off of Greenbelt, and that was not paid. And then there has been some small payment, like a small payment made, but this parcel has been on tax sale multiple times, but it gets pulled off before there is the actual tax sale. We pulled it because it was in the middle of some litigation, and it's my understanding that litigation has concluded, and so our recommendation is that they pay the taxes in full. I know that the Holdaways have sent in a settlement to settle the outstanding tax balance if they pay the $4,600. But again, our recommendation is that they pay the full amount.
So I'm a little confused on this then, because I thought we were talking about parcels, two parcels, one being further east and the other one being down by the lake, and which has been under litigation for quite some time. And so are we not talking about parcels or just a singular parcel itself?
It's my understanding that it's the single parcel, the one that comes to the lake.
So you're talking about the lower one, the one that is under dispute right now with the federal government for who owns it.
Right. Well, so I think there may be a question with the federal government, but it is that parcel that you're referring to that is touching the lake.
Okay. That's all the question I have for you, Adam, for now, anyway. Robert?
Thank you. Excuse me, my name's Robert Fillerup. I'm an attorney in Orem. I've represented the Holdaways on this property since the early 1980s. In fact, I represented almost all of the landowners around Utah Lake in the ongoing litigation to settle the boundary between the state of Utah on the bed of the lake and the upland landowners. That litigation is still ongoing. It was commenced in 1997. As far as my clients, the very last settlement was entered just in February. So technically, I'm no longer representing clients in that case. In about I apologize. By the way, to answer Commissioner Lee's question, this only involves one parcel, and that's the one that's abuts Utah Lake. We settled with the boundary with the state of Utah in that federal litigation back in 2000, and I apologize, I've got it in my outline, but I can't remember the date off the top of my head, but I think it was 2012. It's right here, hang on. In any event, we settled with the state of Utah, stipulated that the state of Utah gave up any claim to that property. But there was the pending issue between the state of Utah and the federal government in what's called Powell's Blue. Powell's Blue starts up north and is an area that extends clear down essentially just north of the Provo River. Just as a sidelight, it's called Powell's Blue because John Wesley Powell himself came to Utah in 1873 to resurvey the 1856 meander line. A guy named Craig, C.J. Craig, came to Utah in 1856 and surveyed what's called a meander line around the entire lake. There appeared to be property that probably should not have been, that was upland, that should not have shown as upland property. So it was resurveyed by John Wesley Powell in 1874. He started on the north end. He actually lived in a dugout just west of the Orem sewer treatment plant. And that dugout existed up until a few years ago when it caved in. It's on the east side of what's called the Clegg Pond. he was here and he supervised that survey, but it got cold in the winter, and so they bailed out. And just north of the Provo River, that meander survey goes down and then comes due east 1.5 miles along a section line. It's kind of a curious meander line. The problem was that there were no upland patents abutting the 1856 meander line at that point. The law is that if you have a patent that abuts the meander line, the federal government cannot come in and survey a meander line below that, and because you're entitled to, under federal law, your property goes to the water's edge at any one time. When Utah became a state, the state got the bed of Utah Lake up to what's called the ordinary high water mark by the Enabling Act, equal footing doctrine. A long story, and I could bore you with all the details about the Boston Tea Party and how that resulted in this, but the idea is that we don't want a federal government owning the beds of navigable bodies of water. So all of the states get title to the beds of navigable bodies of water. And the issue was whether Utah Lake was navigable. Supreme Court in 1987 decided that Utah Lake was a navigable body of water at statehood, and therefore the state did get title up to the ordinary high water mark. It wasn't until 1997 that the state decided to file a lawsuit to claim that title. But in that lawsuit, they admitted that no one on earth knew where the ordinary high water mark was at statehood, so they argued that the meander line ought to be the boundary. But there's a legion of cases, U.S. Supreme Court and others, that said no, the meander line is only established to calculate acreage for the sale of the property and for taxation purposes, but it's not a title line. So anyway, we have ended up settling most of the boundaries. This was one of those, but in Powell Slough, we had this pending issue of what the federal government was going to claim. No one knew, at least I didn't know, what that was going to be until the federal government and the state of Utah settled in 2017. And there, the federal government asserted claim to Powell Slough, and the state said, yeah, we give up any claim to it to the feds. So there's this issue of who is rightly entitled to that property. In the process, because of the settlement with the state, the Greenbelt rollback occurred. Mr. Holdaway and I met with some of the earlier commissioners. Unfortunately, to get that resolved, it never did, and it kept falling through the cracks. So the issue now is who owns that property. If it goes to tax sale, the purchaser of that property at tax sale can never, ever legally obtain title. It's impossible, because it either is owned by the United States government or it's owned by the Holdaways. The Holdaways can file what's called a quiet title action under federal law, claiming that under color of title, and because they pay taxes, they should have title to the property. And so that's why the Holdaways want to pay the taxes, so that they can make that claim. If it goes to tax sale, that's an involuntary disposition that cuts off that claim of anybody else. So a purchaser at tax sale can't ever obtain title. And I think the county would be amiss to sell it at a tax sale under the somehow the idea that a purchaser might somehow acquire some sort of interest in it. We filed a 13, it's Utah Code Section 59-2-1347, a petition to ameliorate the Greenbelt rollback. The Holdaways are willing to pay whatever rollback tax should have been assessed during the entire period. We're just asking that the Greenbelt, the deficiency is something like $68,000 at this point, where the Greenbelt would have only been, a few $1,000s. I take issue with the statements in the recommendation because it says under the recommendation that no error on part of the county is shown. There's nothing in Section 1347 that requires a showing of error by the county. the petitioner doesn't have to show that. So that's a misstatement of the criteria. I do have copies of Section 1347 if it's of interest. Basically, Section 1347 almost gives the commission carte blanche authority to do whatever it wants in regard to taxes. In fact, I have copies for the commissioners if I may take a moment, because I want to refer to that criteria. Apologize, I had them right here handy in a folder. Oh, here we go. Pulled the folder out. So I'd like to present you with a copy of Section 1347 so you understand exactly what it says and what your whoops. Section 1A. If an interested person applies to a county legislative body for an adjustment or deferral of taxes levied against it located in the county legislative body may accept a sum less than the full amount due or defer the full amount due where, in the judgment of the county legislative body, the best human interests and the interests of the state and the county are served. That's the criteria. It doesn't require any showing of error by anybody. It doesn't require any malfeasance or bad faith by a taxpayer or good faith or whatever. In fact, the county could have done everything correctly and a applicant can still apply. Section B, nothing in this section prohibits a county legislative body from granting a retroactive adjustment or deferral if the criteria established in this section are met. The criteria is in Section A. That's the only criteria. The Utah State Tax Commission has taken the position that this basically gives unfettered discretion to a county commission to do whatever it wants in regard to taxes under this section. And so the statement in the recommendation is simply an error on two accounts. One, it says that there's no showing, and then it says it recommends a finding that no legal or factual basis is shown to grant the request. Well, I just presented you the legal basis. And the factual basis is that this certainly would be in the best interest of the county, because if the United States ends up owning it, you'll never get any tax revenue out of it. And so I think it's in the best interest of the county to grant the deferral, or not deferral, I apologize, grant the reduction of the Greenbelt assessment and enter a decision that the Holdaways have to pay whatever Greenbelt tax should have been assessed over the period without the rollback, and they're willing to do that.
Is the property currently on Greenbelt?
Sort of. That's an ongoing question. The answer is yes. They have been paying a reduced amount. There's some questions whether that's just exactly what that is. The property value went up dramatically for a period, and then it decreased. And so the answer is yes. They've currently.
It is currently not in Greenbelt. Clarissa with the assessment.
Well, it's not in Greenbelt, but a rollback amount is not being paid.
Yeah. Are they currently farming the property?
Yes.
Does it qualify for Greenbelt?
Yes, it always has. It's right on the shore of the lake. They use it for grazing, and it could easily qualify for Greenbelt.
Have they applied for Greenbelt?
Well, the question is ownership. Till the ownership's resolved, they want to pay what would be assessed for Greenbelt.
Well,
So
On the county records, who has ownership?
the Holdaways have ownership.
So on the county records, they have ownership, so what prevents them from applying for Greenbelt? I mean, I know there's pending legislation and pending litigation, and I understand that. But if our records show that they own it, what prevents them from applying for Greenbelt?
Well, they've been paying the taxes that have been assessed. So I think the idea that they apply for Greenbelt is moot. What we have is this rollback that way back several years ago that's hanging over their head. They've been paying the current taxes that are being assessed. So it's not that I haven't been paying them, but you said they've been paying the Greenbelt tax. Well,
No, I asked if it was on
they're being
Greenbelt.
assessed something that they're paying.
Yeah, and I asked if it was on Greenbelt. Because typically, when we deal with abating the the Greenbelt rollback, oftentimes it's because there was a gap in farming, but that's the intention of the property and it continues to be farmed. But oftentimes we make that a contingent upon an exception of Greenbelt. At least we've done that.
It's either lack of acreage or
Not
lack of
being
production.
farmed.
So do we know why it was taken off of Greenbelt?
Yes, because of the settlement with the state of Utah, and because there was a somewhat of a, apparently, I'm not exactly sure, but it appears because it was essentially at the same time that that there was a tax rollback instituted.
So back in 2017,
No, it was earlier than that. It was way back in
I thought 2017 is when the state settled with the federal
when
government.
the state and the Fed settled. The rollback happened on this property clear back in I don't, let's see, do I have that in here?
In 2008, do we know why the rollback occurred? Was it a lack of land or was it a lack of farming? Lack of land? Lack of farming? Do we know how long that lack of farming occurred, or are they still not farming it?
But just so you know, there were numerous rollbacks that had happened around Utah Lake as these settlements occurred. You may recall the Evans property. There were a lot. I appeared on several where there was a rollback triggered because of the settlement with the state of Utah, and I'm assuming that's what triggered this one.
Well, so typically a rollback, a settlement doesn't trigger a rollback. What triggers a rollback is if there's a change in ownership or in definition of a property, which would then trigger us to record that property. And when that property gets recorded, then the assessor's office will reevaluate on whether or not that property is being farmed. And so what happens is when a property changes hands, it triggers an evaluation. It doesn't necessarily trigger a rollback, it triggers an evaluation. And then that evaluation would determine whether or not this property qualifies for Greenbelt. And typically, if there's a rollback at that point, it's one of two reasons. Either they didn't meet the acreage requirement, what is the acreage again on this? Can you remind me?
Yeah, it's a lot.
Anybody? Okay, so the acreage is not the issue. We're more than 5 1/4. So then the other one would be, are they farming the land? Now, if there was a temporary reason why they weren't farming the land, we have traditionally been willing to entertain a rollback if there was a temporary reason that land wasn't farmed. And that's why I'm asking, does it qualify for Greenbelt now? Are they farming it now? Because if they're not farming it, then they should be required to pay a Greenbelt rollback. But if they are farming it and there was just a time that it wasn't being farmed, maybe because they didn't want to bring cattle onto the land because of a pending lawsuit. I think there's extenuating circumstances, but there's, reason behind that. What are your thoughts?
Yeah, because any triggers like you mentioned, change in ownership or potential change in ownership if somebody's claiming it is going to automatically trigger
an evaluation, not just a rollback.
And then you usually have to go through an application.
It changed the definition of the boundary of the property with the settlement.
That
would have triggered the evaluation.
That's what triggered the.
So at that time in 2008, were they not farming it?
No, they were farming. They've continued.
So why did they not apply for Greenbelt at that
Because
time?
the question was whether the United States was going to claim title or not.
And that wasn't settled till 2017?
And we did come to the county commission, and we did meet with the commissioners twice, and they said, okay, we'll look at that, and it just eventually fell through the cracks. And then we had the settlement with the federal government that
In
clearly,
2017.
yeah, where the feds clearly claimed. In the interim, by the way, the Holdaways did pay some taxes in those intervening years. Not the rollback, but they did pay additional taxes.
What I don't
it was-
understand is if they were continuing to farm that whole time, why did they not apply for Greenbelt?
Because they couldn't prove that they had title.
They don't have to prove they have title. We have them recorded as the owners, and we're charging them taxes.
That was my legal advice to them, that there was a risk that they would pay taxes on something they could never own.
Or if they pay taxes on it, they can claim that they've owned it because they've been paying taxes on it.
Unless the nation got involved and said, nope, you don't own this.
I'm
You
sorry.
paid- Unless the federal government came back and said, sorry, you guys, you paid it in good faith, sorry you did that, you don't own it, the federal government does. Ultimately, is
Well-
what you're trying to say.
Just recently, that BLM told the Holdaways that they need to get their cattle off this property. So it's coming to a head. So there's no question that they've been farming it and that the feds have been aware of it, and it's an issue.
Which is kind of an interesting dilemma too, because we've dealt with Greenbelt rollback taxes where the ownership of the property has happened and it changed hands, and then the new owner is responsible for the Greenbelt rollback tax. So
We hold the federal
if the
government
federal
responsible.
government is saying that they own it, I mean, they should be paying it. Anyway, it's just because we've had that over and over where somebody buys a piece of property and then they don't realize that they have a lien on that property for rollback for Greenbelt purposes, don't fill out an application or don't meet production, and then they're hit with the 5-year rollback, even though they didn't own it for, say, 4 years or 4.5 years.
Right.
Because of the peculiar circumstances of this property, that's exactly why we applied under Section 1347, because it doesn't fit under any of the other code sections in terms of Greenbelt rollback and all of that. And
Yeah, in the Board of Equalization, this would never fit. It doesn't fit within there
sorry,
at all.
I-
In the Board of Equalization, this would not, it doesn't fit. That's the reason why the 1347 makes sense to
Now,
file under.
1347 doesn't apply. It's the county commission that has jurisdiction, not the Board of Equalization under
Right, that's what he's saying.
1347.
So I would be interested to see them apply for Greenbelt status because just in the interest of us being consistent, we've waived rollback in cases where the land is actively being farmed and has actively been farmed, and there was just fire or drought or even just the health of the owner, and maybe there's a few years that they can't farm.
Right.
But we've always made it contingent upon approval of Greenbelt in the last few years. And so I would be interested in saying, well, rollback could be abated if they're going to actually apply for Greenbelt and have Greenbelt.
Do you feel confident that they can show production for the last couple of years?
Oh, yes, no question.
Well, that goes to your point right there.
And I don't have any
If they
problem
do
with
an
that.
application for Greenbelt or for Greenbelt status and prove production for however far back they can go, 2 years at least.
Yeah. Prove production, show us it's on Greenbelt, and then figure what the taxes would have been on Greenbelt, and then look at what we're willing to abate. But just abating it because they say, well, it was under dispute. I don't care if it was under dispute. Were you farming it or not? That's what I want to know.
And that's fine, and we would agree with that. So if you want, we can
The
continue this
application.
without date. We can get an application in soon, get that processed, and bring it back on the calendar.
How long on average, I'm looking at the assessor's office now, how long on average would it take to, like, how long would we need to continue this for reasonably for them to apply for Greenbelt and have
Might
that?
be better if we just strike this. And
Just
then-
strike this?
And then
That would
let
give
them
them
go
more
through the
time.
process. Otherwise, we're trying to pick a date that might be tough.
Okay, would that be easier?
As soon as this meeting is over, I can generate an application, and then it's just when the owner can process it and get it back to us. So, I mean,
Great.
within a
Have you-
month is
We can have it done tomorrow.
relatively easy.
I just don't want to have it indefinitely, you know?
Right. Yeah.
Well, there'll be a tax sale next year, so it won't be indefinite.
Well, we don't want to go that long either.
Yeah, that's what I mean. I don't want it to be that long either.
Yeah.
Well, I
him 2
recommend we
months.
continue it to a date certain that's maybe 3 months down the road and see where we are,
Yeah.
rather than
So you're
indefinitely.
thinking July, August, September timeframe?
That means Alice has to keep track of that.
Say again?
September timeframe? September? You're saying 3 months?
Or sooner.
Yeah, I mean, the applicant simply has to provide the financial records to show what, 50% of the statewide average income for that kind of property. There may be an issue because it's grazing as to, what are there, 4 or 5 categories of grazing property under the tax commission's rules, so we'll have to decide, but
They'll still be measured by AUMs on that anyway.
Yeah, I don't think that would take very long.
no, I think 3 months is,
3 months. Yeah, so I wouldn't mind seeing this back in 3 months. We don't have to necessarily, we can strike it now and we don't necessarily have to say continued. But I would think they would need to get back on Greenbelt, get their status back in good standing where they think they should have been. And then maybe let's look, and then, and then we could consider it. But I don't even think we should consider it if they're not even on Greenbelt, right?
Yeah. Okay.
remember, it's being taxed as if it is on Greenbelt currently, although, but we'll file the application.
She's saying otherwise.
That might be what they're paying, but that might not be
Well,
what
it's
it is.
certainly not being taxed on the assessed value after rollback. Oh, well, okay.
Okay, we'll go through that process and
Yeah,
Yeah, let's
you
go through the
don't need to
Greenbelt
deal with
See you
that
process.
after
at
the
this
summer.
point.
Yeah, I would like to see it about 3 months, September sometime. Okay.
Thank you.
Sure. So,
Okay.
do we need to choose the date now, or you'll,
Well, I mean, Alice, if we do a date now, is that difficult for you? September 14th? Would you be okay with that? That gives us just shy of 3 months, 1 week shy, because
That'd be fine.
3 months, the date that's 3 months from today, we don't have a meeting. So if we did 1 week shy of that, September 14th.
fine.
Okay,
Okay, so well,
there you go.
there you go,
Okay, thank you.
September 14th.
And it can be sooner.
Yeah,
Yeah, thank you.
yeah.
Thank you very much.
As this was brought to my attention a couple of months ago, so I handle the land valuations. And in 2016, we reassessed the property, kind of.
Okay, so
we
was a
reappraised
reassessment.
it.
Okay,
Well, so we reappraised the market value of that property. So previous to that, we had it valued at $124,000. In 2008, we had it at $311,000. In 2016, we revalued that to be $24,800, so significantly less because of the kind of property this is. It's not readily developable. I mean, it is high water. You know, there are some other issues going on. So, given that the taxes weren't paid, one of the options that we looked at was, what happens if we take the assessment that it was in 2016 and apply that all the way back to 2003, which is where the grain belt ends. And so that may be an option as well. And then, take what that assessment would have been and then apply penalties and interest.
right,
on
because
top of
previously it was
that.
assessed as a developable property, but after reassessment, we realized it wasn't developable. So I would say after they get Greenbelt, let's look at those options.
Yeah. So there is some other things that we can do besides putting them in Greenbelt retroactively, because, in 2007, 2008, when that Greenbelt would have been assessed, and they had 45 days to appeal it. They did not appeal that. And so now retroactively adding Greenbelt.
But what we could do is we could abate the rollback, put them on Greenbelt from this point going forward, abate the rollback, and then look at the taxes between those times.
We could also,
So I think we've
just
got
use
quite a
the
few
lower
options.
value instead of the
Because it's still,
Greenbelt.
the good thing is it's still the same owner.
Right.
And so you're not crossing a line of a 5-year rollback.
Yes.
That's always been
Right.
our problem, is that you have a
Yeah.
new owner, and all of a sudden now they're looking at 5 years, and so you want to have 5 years as they're moving forward. But in this case, you have the same owner.
Yeah. So let's get it on Greenbelt. Just, it should be anyway. And then let's look at the assessed values after that. Okay. Thank you.
Okay, thank you. The last one,
Continue
no, till September 14th.
September 14th.
Continue it to September 14th.
Yeah.
Yeah.
Yeah. All right.
The last one I have, Commissioner, is Besant. Okay. This one is where a property owner had a death in the family, was out of the country for 3 months, came back, then they didn't pay the tax until May.
May.
So, a little over 3 months there. May 6th is when it was actually paid. As I look down through this, and I realize, I mean, again, the county, there's no error on this. They functioned within their box and their parameters, and I think we're looking at it from within the box that we have, which is this
Human
ability
interest and best interest of the county and
to
state.
look at it. So I want to make sure and state that. And when I was looking at this, I am sympathetic to out of the country during that 3 month period of time, and then but I'm not sympathetic to coming back in January and then not addressing it until May, which is another 3 month period of time. And I think they're asking for, if I remember correctly, what was it? It was it's not the tax, but I think they're asking for the abatement of
Penalties
the
and interest.
penalties and interest. And for me personally, on that, I'm comfortable with taking that penalties and interest and cutting it in half. I don't know what your thoughts are.
How do you come up with half and not?
Well, I did half roughly because it was 3 months they were gone, and then they came back for 3 months and didn't pay until after so it's about a 6 month period of time.
They have fees.
In which they had fees and interest. They had fees and interests attacked on, and they could have paid that as soon as they got back, and did not. And so I'm okay with the 3 months where they were gone out of the country, recognizing they can pay online, they can pay on the phone. There's all kinds of options that could happen there. But I fully understand what happens when there's, a death in the family or whatever that's going on. There's a lot of chaos that's happening. And so just out of the best human interest there, I'm okay with the abating half of the penalties and interest, but not the half where I think they should be responsible to pay. They were here.
My thought was that they should pay the entire amount. I'm curious, the death of the family was, I don't know the relationship, who it was, what turmoil this caused the family that they were delayed that long. So there's a couple of questions I had. Is there anything that's not written in here that you have?
Adam Beck, Utah County Attorney's Office, they did provide some documentation of a death, took some pictures, and so we don't know exactly why they were gone so long, but there was a death in the family, and that's about what we know.
Sounds hard-hearted, but to me, I would rather they pay the entire amount because, again, this is 3 months after they return. And
Jeannie Bowen, Treasurer's Office. So I helped with them with their appeal. They knew that the sister was dying. That's why they were there for so long, as they were kind of like how we do hospice, right? They went and helped with her last few months. So
they were hospice during those 3 months that they were gone.
so the sister was, right? That they knew she was on her deathbed. So they went there to be with her last couple months of her life. And then she passed, and that's when they then came back. And I don't know why it took them 3 months past coming back, but that is why they were there for those 3 months. But thanks.
I'm happy to go with half.
Have you guys like half? I can agree to half.
That's all I have on those. So I'll make a motion then that we approve the property tax actions as stated in number 4, with the changes that as stated in the Revere Health one, where we take and approve that one, and that we have already addressed, and that on the Holdaway property, that was September 14th. We moved that one, continued that one September 14th. And then on the Besant issue, that one we take and abate half of the interests and penalties.
Okay, we have a motion then?
That is the motion.
Yep, and I'll second that.
Okay. Well, all in favor, say aye.
Aye.
Aye, passes 3-0 with those changes. Okay, number 11, authorize a change to the staffing plan of the Sheriff's Office to add one full-time career service lieutenant enforcement position. I won't read all the others. I just wanted to, this follow-up email that came in said that this would not actually be filled until sometime in early next year.
No, the email, the email said that they had originally wanted two positions, the lieutenant and a sergeant. And they want the lieutenant, but they're going to delay the sergeant until later. Right?
Let
That's
me
what I read.
reread that again. Okay.
That's what I read too.
I just read the email that Sheriff put out. Yeah, that's what it said.
That's what I understood.
So it's not both positions, just the one.
Yeah,
I think maybe the confusion was the beginning of the fiscal year for Vineyard because they're starting in July 1st.
right.
So,
So their fiscal year starts July 1st, and that's when they want the lieutenant.
Yes.
And then they'll look at getting the sergeant after January if
Yes.
their budget.
if the budget allows, yes.
That's what I read.
Okay, then that was my misreading. I thought
Okay.
you were referring to both positions for next calendar year then. Okay, that
The
changes the whole.
lieutenant positions being proposed to be added this July 1st. And then they will reassess, and we'll have discussions in January when they look at their budget mid-year, and we'll assess whether they can add that sergeant position, so.
Right.
Okay, I'm happy with that explanation. Thank you very much.
Thank you.
All right.
Make a motion,
I'll make a motion to approve item number 11.
Second.
and all in favor say aye.
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 Aye, that passes 3-0.
That's it.
And we've continued item number 20 until June 20th. That concludes our regular agenda. Any public comments? Okay, seeing none, we'll now go into our closed session. Thank you, everyone.